Yeah, well, I'm an attorney. I'm based in New Jersey. I'm licensed New Jersey, New York, and Kentucky. I practice nationally. For the right case, I'll go to other jurisdictions. I have cases in Ohio, and we're going to have one in Colorado, one in North Carolina soon. But I started out really as a commercial litigator, business litigation, fraud cases, RICO cases, civil RICO cases, and when the first COVID vaccine mandate came out in Manhattan with Bill de Blasio as mayor, I was retained by a number of restaurants and gyms and individuals to sue to have it declared unconstitutional. And although the record will show that we lost that case, in reality, we believe we got 3 different mandates pulled, because every time that the court was about to hear the arguments, they would pull a mandate and say, well, the case is now moot. There's nothing to argue. And so 3 times they said, no, it's not moot because of this mandate. And they'd pull that one. It's not moot because of that mandate. They pulled that mandate. And so by the time we were done, we had no mandates left to fight for our case. And then we were thrown out. So the record shows we lost, but I really think we won that one. Yeah. My wife, now business partner, law partner, Gwyneth Murray Nolan, she also was taking on masking cases in New Jersey, and we were equity partners in a pretty big law firm in New Jersey, and they didn't really like the fact that we were doing these kinds of cases, and they didn't like the fact that I was on, say, Fox News or Newsmax, and so we had a splitting of ways. We opened up our own firm January 1st, 2022. And since then, the calls haven't stopped, because we're some of the only attorneys who do this kind of work. We do the vaccines, masking, diversity, equity, inclusion stuff, transgender things, and now here we're fighting President Trump's gag order. But this is what we do every day. Well, I do know that Trump's lawyers were doing something. They were trying to get it done, but they're also, fighting a criminal defense case under incredibly adverse circumstances, including that we argue the judge was highly conflicted.
Yeah.
My client is actually a media company, a podcaster called Good Logic LLC. Good Logic does legal podcasting. They're a very successful legal podcaster. And he, Joe Neerman is the guy who is behind Good Logic, and he does his daily show. And he had this idea that, hey, this is a violation of the freedom of the press. He was looking for a constitutional attorney. People gave him my name, and next thing you know, we were connected, and that's how this started. Well, so actually, there are really 2 gag orders that really need to be talked about. The first one happened in federal court in Washington, D.C., and that related to the charges, the claims that I guess that the January 6th type claims. And there's a Judge Chutkan down in the federal court in D.C. who imposed a gag order. And the gag order was based upon sort of a lower standard, I'd say, than the gag orders that in the past might have been put in place under federal standards. In New York City, in Manhattan, Judge Merchan, who is the defendant in our case, or they call him petitioner and claimant and whatever. But basically, he's a defendant in the case. We sued because he imposed a gag order on President Trump based upon the D.C. gag order and based upon allegations by the prosecution, Alvin Bragg, that somehow or other his words were going to infect the case, going to might scare potential witnesses, et cetera. And so they imposed this gag order, and then they imposed a second gag order, which was to expand the gag order to include that Donald Trump could not do any criticism of the prosecutors' families or the judges' families. And that is where we see the biggest problem, because our position is that Judge Merchan did that. In doing that, he prevented President Trump from speaking about conflicts of interest that judge had because of family members' activities. And that is we say, gross violation, not only of President Trump's First Amendment rights, Our clients, the press's rights. My client had tried to get an interview with President Trump and tried to get some questions answered about these conflicts and was turned down. But also President Trump's right to a fair trial, which ultimately resulted in, I think, 34 convictions. It is our fundamental, this goes to our fundamental liberty as citizens. It goes to the fundamental right of the press to hear from the person who's being charged with criminal crimes. And it especially goes to the criminal defendants' rights. Look, this is much bigger than just Donald Trump. Think about any criminal case. In every single criminal case that came before President Trump, the whole notion was that the process was to protect the defendant's rights because the defendant is innocent until proven guilty. The accused has all of the rights, and the prosecution does not have the rights. The prosecution bears the burden of proving beyond a reasonable doubt. It's a very difficult burden. Right. And here, Judge Chutkan first and then Judge Merchan, they decided that, no, we're going to gag the criminal defendant so that the prosecution can have an easier case, so that the court can have an easier case. In the past, Supreme Court cases, and actually, other courts too, lower courts, including one in which Justice Sotomayor sat as a circuit court judge in the Second Circuit in New York. The courts before have always employed a standard of there has to be an imminent threat to the trial to gag somebody. And the only way I could see, and I've put this in my papers, the only way I could see a criminal defendant creating an imminent threat to the trial is if perhaps his words create a clear and present danger of jury tampering, say. Then you go, okay, that can't be allowed. But otherwise, the criminal defendant has the right to speak to the press, has the right to declare his innocence because you're presumed innocent. Why shouldn't you be able to declare it? And you have a right to talk about things like the judge should have to recuse himself because his wife and his daughter are creating a conflict of interest for him that makes it actually under New York law requires him to recuse himself. In this case, we argue that Judge Merchan was conflicted, that he put the gag order in place and prevented the man with the biggest microphone probably in the history of the world to speak about these conflicts. And as a result, he presided improperly over a trial that resulted in a conviction of a former president of the United States, something that is entirely unprecedented in our nation's history. I don't really know Merchan's background per se. I do know that his daughter, I believe, is a publicist for Biden Harris. And there's a news report out since the convictions that in the quarter of the year during which the trial took place, her company was made $12.4 million more the quarter this year than they did that same quarter last year. And why would that be? Well, I wonder why. Your dad's the trial judge. I think it's a fair statement. Yeah. The other thing is his wife works for Letitia James, the Attorney General of the state of New York, who campaigned. And Laura Loomer put out a piece where she has the video of Letitia James shouting in a bullhorn about President Trump, lock him up, lock him up. Well, Letitia James's employee is Judge Merchan's wife, and Judge Merchan, guess what? He may be locking Donald Trump up. Yeah. That's a conflict of interest. In New York State, the New York law on judicial conflicts is that if a judge is within 6 degrees of somebody who has a financial or important interest to the case, the judge has to recuse himself. Here you have 1 degree away. You have a wife and you have a daughter who have significant conflicts of interest. That is automatically, under New York law, as I read it, a requirement that the judge recuses himself. But the judge silenced President Trump, so he could not talk about those conflicts. So we started, my client actually is, Joe Neerman is an attorney. He's not a constitutional attorney. He has this show. It's an excellent podcast.
Yeah, it's great.
I hope you listen to it. It's terrific. So Joe had this concept, and he actually did the initial filing, both for himself and for Good Logic. And he filed in the New York First Department, which is the appellate court above the trial court, because that court would have jurisdiction over Judge Merchan. I then came in, substituted in for Good Logic, and took on the arguments for Good Logic. And ultimately, During that process, the First Department, usually appeals are a very open process. They kept everything under wraps in the First Department, so that everything was kind of privately filed. The public couldn't even see that this was going on. So we had it was essentially, we were sort of under lock and key without there being any reason to do so. And so the public was really deprived again of hearing or seeing the papers that we were putting in, hearing the arguments we were making about Judge Merchan. It was as the trial was going on.
Wow.
The decision finally comes down on the same day President Trump was convicted. The First Department puts out its decision saying that we lose. So we then filed an appeal to the New York Court of Appeals, the highest appellate court in New York. The Court of Appeals ultimately determined that they had no jurisdiction because we didn't present a significant question of New York constitutional law, which of course we did. We said under New York's the equivalent of the First Amendment. It's actually broader than the First Amendment, and New York is required to provide the greatest of protections to people as free speech. In this case, they just said it wasn't significant. Well, it's kind of odd. But anyway, what we've done now is the next step is to go to the United States Supreme Court. We're seeking an injunction in the state courts of this gag order.
Right.
And so we could either file what they call a petition for certiorari, which, the whole Supreme Court will look at in, 6 months or 4 months or whatever, or we could file an emergent application, an emergent motion seeking to have a stay of the gag order pending our appeal to the Supreme Court, which is what we've done. That has to go to the justice who is in charge of the particular Circuit Court of Appeals. There are 13 Circuit Courts of Appeals. There are 9 justices, or a chief justice and 8 justices, and they're responsible. They're all assigned to certain 1 or 2 circuits. Justice Sotomayor is the justice in charge of the Second Circuit, which covers New York. So we have to make the application to Justice Sotomayor, who, as I said, has previously ruled on a very similar type of argument about a gag order while she was sitting on the bench as an appellate judge, and ruled that the gag order, is very, very, very strictly construed against the state trying to impose a gag. So we're hoping that she, looks at this and gives it an honest look and recognizes the merit of our arguments and sends it on to the entire, does a stay and sends it on to the entire Supreme Court for review. Well, we're hoping, as I understand it, our motion is in the hands of Justice Sotomayor at this point.
Great.
It should have been delivered to her probably yesterday.
Great.
And I don't know what the timing is, but it is an emergent application. So, the ideal would be that Justice Sotomayor recognizes the merit of the arguments and places a stay on the gag order,
right,
which would then free my client, Godlewski, to interview President Trump and get questions answered, and it would free President Trump to speak to whomever he wants in whatever forum about it. Look, the cases, and to your point, the cases in the past have been, the Supreme Court cases have been very clear that this is also, the free press is also a right of the public to hear.
Right.
And nothing is, and there are cases that say there's no time more important than during an election for people to hear the things that are important, because this is how we decide our future as a nation. And what's happening with the order is that our ears are plugged from hearing what it is that we should be hearing. Look, you may disagree with me completely. I may disagree with you completely. I may think Donald Trump is the worst, most horrible person in the world, and I may totally disagree with him. But that doesn't change the fact that he has a right to say the things that he needs to say in defense of himself. And it also doesn't change the fact that there are other people who may not feel the way, who may not feel adverse to Donald Trump, who may be on the fence, as you said, and who may say, gee, I thought this guy was a convicted criminal, but there's some actually, what is this? This is the judge who's got a conflict. How do I square that? How does that affect my way of thinking about things? And this is very important. This is not some kind of minor thing. It goes to the core fundamental constitutional values of our society. Well, one of my arguments I made to both the First Department Appellate Court and to the New York Court of Appeals is, I think it's a very important argument, which is that In the context of this case, there is evidence that Judge Merchan was presiding over probably one of the most sensational trials in American history. A former president who is being charged with felonies under New York law, and he's running for office. And that there are significant questions that the trial judge is conflicted. And one of my arguments was, look, I care about the rule of law. I'm in this. I'm not a politician. I'm a lawyer. I took an oath to uphold the Constitution and laws of the United States. How does this reflect upon the whole New York judicial system if there's a sitting judge in a case of this importance who is conflicted and for the whole world to see? And how does that make the court look to the people who may be litigants in that court, to the citizens of the state? It destroys the fundamental underpinnings of the court's credibility, in my view. And that was one of my arguments, that for the sake of the judicial system itself, this needs to be examined very closely. And maybe I was wrong in my arguments, but they have to examine it. But they didn't. They basically went along with the D.C. court, and they didn't really. Interesting side note. One of the things we're arguing in the Supreme Court is that, one of the reasons a Supreme Court will take a case, oftentimes they take very few cases, is that if there's a split among the circuit courts of appeal. So if one circuit court of appeal finds X and the other one finds Y, there's now a split in the authority and so the Supreme Court wants to create a singular rule of law, and it'll then take the case. Well, here we have a split in the circuits because in Judge Chutkan's order went up to the D.C. Circuit Court of Appeals, which affirmed her. You talked about why didn't Joe Biden or why didn't this person have a problem? There's another case called U.S. versus Ford, which was in the Sixth Circuit Court of Appeals. And that was Congressman Harold Ford, a Democrat. And the Sixth Circuit Court of Appeals, and actually the Congressman Ford, I think you'd see him on Fox News after the debates, right? Right. And so Congressman Ford was being tried for mail fraud and bank fraud or something like that. And the trial judge gagged him. And the Sixth Circuit got the case and said, no, you can't do that. There's no clear and present danger. And in any event, it's not the place of the court to gag a criminal defendant for its own convenience, to make it easy for the prosecution. It's the prosecution. It's too bad that it's inconvenient. This is a person who's being charged with crimes and that his liberty is at stake, and you can't just gag him. And contrarily, the D.C. Circuit said, they had a lower standard. They really didn't look at Ford, and they gagged President Trump. Much the same reason, because for what I say is the court's convenience. He didn't present a clear and present danger of anything. So there's a split in the circuits, and I'm really hoping that the United States Supreme Court will look at this split and say, this has to be decided. This is much too important not to decide right now at the height of an electoral season. I do believe that my client did a GoFundMe, not a GoFundMe, but a Give, Send, Go. I think it was Ungag Trump or something like that. But I don't have the link. So I think that's a way to, because the idea is that it's going to cost money. I think he wants to pay me, which is nice. But I'm not trying to do this to get paid. So, but I want to bring public awareness to what's going on. But there's also costs involved in an appeal. And we talked about actually hiring a Supreme Court litigator if this does go to the United States Supreme Court to argue the case. And we have some very good people in mind for that, some excellent people in mind for that. So that costs money. But the other thing is, and I'm admitted to the Supreme Court, I'd love to argue it, but you know what? We have to know our place. And if there's someone who is excellent historically at doing it, that's the person who should be arguing something of this importance. But the other thing is, we do cases, like I said, all types of cases, DEI, we do them nationally, and you can reach me on my email. It's ron@mnblawfirm.com. I'm pretty accessible still. But for the most part, we do cases that are very difficult. And actually one of the cases we have, you want to help, my wife is actually being prosecuted for not wearing a mask at a school board meeting. She was actually arrested at a school board meeting.
God.
And the trial is next Friday, October 11th at 9 a.m. in the Cranford, New Jersey Municipal Court. And we are looking for people to come and provide support, to come and sit in the courtroom and provide support in this little courtroom. She was charged with defiant trespass after 8 months of arguing without a mask, of going to school board meetings, arguing for kids with special needs, including her own, who were being harmed by these masks. They decided to put handcuffs on her and arrest her. I'd say it's political. This is their pound of flesh. They want to punish her. They want to teach people a lesson that you shouldn't go up against the school board. You could get in trouble. Right. Well, that doesn't fly with me. It certainly didn't fly with her. And she's an incredibly brave woman, and she's very principled. And I'm super proud of her. I'm super proud not only to be her law partner, but to be her husband, because she really did the right thing, and she took a hit for it. Yeah. And we've lost friends and family because of this kind of stuff, and that's just the way it has to be, because there are bigger issues involved in this than just who likes us and who doesn't. Look, my grandfather escaped communism in 1948. He risked everything to be free, everything precious to him, his family, his fortune, whatever, everything he had, he risked. He came across the sea in a 10-horsepower boat in a storm, lost his compass, was lucky he didn't end up in the same place he came from and get shot. I don't know where my kids go on their 10-horsepower boat, or my grandkids go on their 10-horsepower boat. This is the last best hope on earth. I think that was Ronald Reagan who said that. And we have to fight for it. We have to preserve it. And not everyone's a lawyer. Not everyone's got the big microphone, but everyone has common sense. Everyone has the ability to go to the school board meeting, to go to the town meeting, to go talk to their senators and congressmen. And the one thing you cannot do, you cannot allow yourself to be cowed and to be bullied into silence. Right. The threat of being canceled is really, why do they want to cancel you? Because they're afraid of you. They're afraid you're going to speak up. They don't want you to speak up, because then they have to answer questions. So they bully you. And you just can't let them do that. And if they bully you and they want to turn you into a cartoon, well, bring your neighbor. And they have to turn that person into a cartoon and bring another neighbor. This has to keep on going, because if we're silent, we're all going to get steamrolled. And we cannot allow that to happen.